Good afternoon. Let me welcome you to our special event today, where we are joined again by our very special guest, Dr. Nubia. My apologies for starting a little bit late, the challenges of the virtual world at the moment, but we hope and believe we have addressed our little technical gremlins. So delighted to be welcoming you to our special event today. I say we're joined again by Dr. Nubia because Dr. Nubia has been our special guest presenter before. Last year, Dr. Nubia was our speaker and our special speaker at the close of our Black History Month celebrations. However, today is different because this is a key point in our cultural diversity efforts as we invite not only our colleagues, but also our REACH alumni members, our clients and contacts alike. So welcome to you all. My name is Vin Banj. I'm a partner at Taylor Wessing, and I have the enormous pleasure of co-leading our Cultural Diversity Network. This event today marks almost a year to the day when, following the tragic events, the killing of George Floyd, we held our own town hall session to start a more powerful and more engaging discussion on the topic of race diversity and racial inequality. It was a huge opportunity to reboot, to reset, to kickstart, indeed a fresh start at how we engage with this particular topic. And that didn't happen for us in a vacuum or in a stale, cold corporate meeting room. We had voices, we had presence and engagement in this debate. Personally, I talked with more than 20 people, I recall, in one particular week, where the discussions are all about what are we doing on this topic? Can we do more? The profession needs to change. How can we change? And how can we as colleagues help in that process of change? And also, I don't want to be silent, but how can I show up without getting it wrong? And how can I show up and really make a difference? And we shared this in our town hall discussions, where we talked about the impact of race discrimination, what we go through as minoritized communities in our everyday lives, and our brave junior colleagues showing strength and direction in their involvement and leading the way in that particular discussion. We knew we had a very clear mandate, an expectation and support from across colleagues that inaction was unacceptable, and requesting support on education and a space to grow. So we all know that we have a part to play to move the needle on tackling racial diversity. Our commitments were reinforced right from the very top at Taylor Wessing and led to our first strategy, a race ethnicity strategy that we launched in September last year. And under that strategy, we began a series of engagements and a series of actions against the three fundamental pillars that we had outlined. And that's first, to recruit more diverse talent. And second, to improve the experiences of our colleagues. And third, to engage our clients and communities in this particular strategy. And this has empowered us to take action. So this has been a real living and breathing strategy. And we celebrated the Black History Month celebrations last year, bigger than we ever did before. We marked cultural events and will continue to do so to be more visible and celebrate with our colleagues, celebrating culture as enrichment and not division by difference. We undertook to act. And some of those actions and achievements, and just some of those, include education and training on anti-racism. And not just education and training in perhaps the way you would have seen it in days and years gone by, but a real up-to-date training session that was made available for all the leadership, all the partnership, and all our colleagues at Taylor Wessing. And we had more advanced training that followed up on that just this year, focusing more on allyship and then allowing everyone to have the tools to become a better ally. We broadened our roles and support for our community organizations like Aspiring Solicitors and the Black Solicitors Network, with more Taylor Wessing ambassadors present than ever before, and more support for their respective programs. We signed up to the Race Fairness Commitment to challenge ourselves to measure and to maintain the pace of progress. We've launched a new mentoring program, which I'm pleased to say also involved the whole of the leadership too. So this really is led by example and from the top. And we overhauled our graduate talent recruitment processes to better tackle and minimize the risk of bias. And this was a major effort and shift with huge energy from the whole team. And the early results show that we have the most diverse talent pool into our brand new vacation scheme, which started just this week. And we became one of the first law firms to commit to the 10,000 Black Interns project. And so many more achievements in such a short space of time that I could mention too. But I wanted to simply give you that flavor of the wave of change that we put into motion and will continue with. And we have to continue as we see the debate around us on this topic still exists, whether it's taking the knee in football matches or in that other beautiful game, cricket, of course, also debating the challenges that they have there too on the topic of race. And there are challenges all around us with the other voice that needs to be tackled and engaged with. And it's disheartening sometimes to hear those voices and to hear that. But I certainly won't be disheartened. Instead, I will be energized to push harder and lead harder on this particular topic. And this, if anything, shows and validates our need to keep the conversation going, to keep our ambitions high and continue to push for more discussion, more change, and take action to get there. And we are proud to have taken action and continue to do so. Another example was supporting the Windrush Pro Bono initiative. And this was and is a very proud moment for Taylor Wessing, where we as lawyers can ply our trade to help those, and particularly those who found that they became victims and they need access to justice. And our support there will allow them to have access to justice, and in particular, access to navigating the complexities of the compensation scheme. And this is how we believe at Taylor Wessing we can bring intelligence and passion and encouragement for our colleagues to be part of this journey. And as I mentioned Windrush, and I do so because it's part of our history. And it was on the topic of selective history that Dr. Nubia first presented to us at Taylor Wessing on hidden histories where race is concerned. And today, Dr. Nubia joins us to explain his work, to shine a light on the role of law, lawmakers, and the law in our history, especially where race is concerned. So let me introduce Dr. Nubia to you. For those of you who haven't had the pleasure of interacting or hearing Dr. Nubia before, Dr. Nubia is a pioneering and internationally recognized historian, writer, and presenter who is reinventing our perceptions of the Renaissance, Black history, Black studies, and intersectionalism. Dr. Nubia is the leading historian on the status and origins of Africans in pre-colonial England from antiquity to 1603. He has developed entirely new strands of British history, which includes Africans in ancient and medieval England. Dr. Nubia is also an expert on diversity in Tudor, Stuart, Georgian, and Edwardian England and Britain. He has helped academia and the general public to an entirely new perspective on otherness, on colonialism, imperialism, and the Black British contribution to the World Wars I and II. He is a recipient of numerous prizes and awards. He has written over 40 articles on Englishness, Britishness, and the historical method. He is an internationally renowned speaker and has been a keynote presenter at many, many venues, including the Houses of Parliament, at universities throughout the UK and America, and has been a consultant and presenter for numerous television programs. And today, I'm delighted that Dr. Nubia joins us. So sit back and enjoy the presentation he's about to give us. And feel free to put questions in the chat facility that you'll see on the screen, and we'll do our best to get to those at the end, time permitting. So without further ado, it's my pleasure to hand over to Dr. Nubia.
Thank you, Vinod. Hope everybody's fine and well. I'm the reason why it's slightly delayed today. Unfortunately, the difficulties of working from home is that the computers and the systems don't always work for you, and this is one of the opportunities. So I've been running around. So if you see me perspiring or looking slightly flustered, you know the reason why. It's not because I'm of the meeting necessarily. So I wanted to begin with an idea or a concept that's fundamental, which is our understanding of the law. Now, in some way or form, I suspect that everybody who's listening today has some idea about what the law is, or some idea or concept of how the law operates. And I wanted to look at, well, underpinning the ideological and the philosophical perspectives which frame and shape the law, and also unpick our perceptions of it. William Shakespeare in famous play called King Henry VI, Part 3, begins with a line, "Let's kill all the lawyers." This eponymous line is uttered by a minor character called Bill the Butcher during the Jack Cade Rebellion. It is a line which embodies an ideal or concept, which is that lawyers are seen as representing, protecting, and defending public property. Lawyers are also seen as defending the status quo. And lawyers are perceived as not being the instrument of social change or bringing forth social equality, but the instruments of conservatism with a small c, and the protectors of those already who have power. And that's why Bill the Butcher in the play says, "Let's kill all the lawyers." Now, of course, that's an extremely provocative and violent action. Why would the law have such a bad reputation that people would say these sorts of things about lawyers? Well, some of it is to do with the very nature of what the law is about historically. It is, in theory, a system of benign rules which a particular country or community recognizes as regulating the actions of its members, and which it may enforce by the imposition of penalties. These rules can be customary rules and traditions, or they can be the kind of binding laws which states use. They can be in the form of statutes, those are things passed by Parliament, or they can be common law, that's a law, of course, that you know, that is made by the judicial system. Or it can be laws such as we have in England, such as equity, these coming from principles which fused with the law in the 19th century. Now, law can also be defined by being criminal or being civil, or it can be thought of as being public or being private. Now, when we think of the law today, we think of the law as both a sword and a shield. A shield that protects rights, and a sword to enforce those rights. And we think of law being not only national, but also regional. And by regional, I mean European law. So, for example, we are a member of the European Convention on Human Rights. And the European Convention on Human Rights provides certain fundamental, inalienable rights. First generation, second generation, and some third generation rights. They are connected to civil rights. The civil rights are those rights arising from within a nation state. Together they form a canopy of laws, a canopy of rights, obligations, and laws which protect the citizen, even against the state. The capacity of the individual to take the state to trial is a fundamental aspect of the legal system. And even to take your nation to trial is also a fundamental aspect of the international legal system, bound up in the International Criminal Court, etc., etc. But historically, that's not what the law has been about. The law primarily in Western Europe has been about the right over property, even if that means that civil liberties are infringed. This is why the law in the past has become was an instrument often used to support the inequity of individuals, inequality towards individuals, and even enslavement and even genocide. So, to really explain this, I thought we might, for a moment, just sort of think about how English law developed, because that might give us an idea of how the law became what it did, and also why it changed. Feudal law wasn't created to protect the rights of serfs and villeins. It seems like a contrite thing to say, but it's true. The law was there to enforce manorial obligations, to ensure that land tenure and those that worked the land did so and followed their obligations. And it was there to enforce manorial rights, i.e. the right of the landlord over their serfs and villeins. When feudalism changed to mercantilism, those same preoccupations remained. law continued to protect the wealthy. It favored those with high status. It favored those with the capacity to employ lawyers to protect their interests, rights, and privileges. And it tended to infringe on those of the lower classes who are either illiterate, semi-illiterate, or didn't have the wealth or the capacity to employ lawyers to protect their rights and interests. So the law got a reputation for protecting property and privilege and being in defense of the wealthy classes, the middle classes. Having said all of what I've just said, I'm going to contradict some of that a bit later on, but that's the key thing that I want us to think about. So this idea meant that despite provisions like Magna Carta 1215, Bill of Rights 1689, Habeas Corpus Act 1680s, the law primarily was there to protect the status quo, to protect those with the money interest, to protect those with property. Now, what I'd like us to do is to just look through a few early modern cases, because this might help us to understand how the law got such a bad reputation and how lawyers got such a bad reputation. And I want us to think about the ratio, the obiter, and the material facts of these cases that aren't often spoken about, but are in fact really, really important. One of them is the case of Mariana Moriana of 1470. This was an African woman in England in the 15th century. This woman was sold, or attempted to be sold, by her employer, and who attempted to have her rights assigned away. But in fact, the court defended her capacity to protect her rights and stood against, in this case, the rights of the owner or the rights of the employer. And they said, equivocally, that her status couldn't be changed. So she asserted that she was not a slave. She asserted that she was a worker. And as such, that her rights were coming from the Statute of Laborers, 3051, or the later acts. Not that she was a slave that could be bought and sold. And the court said that they had no power to change her status, and that they will assume she has rights if she says that she has them. This doesn't mean that the law is actually going to be a sword to promote her rights, but it will defend the fact that she has rights if she says that she has them, and she can prove this. So this case is really important because it shows that if an individual had the capacity to assume a right under Magna Carta or Statute of Laborers or any under provision, the courts would tend to say, okay, we recognize that that right existed. This provision maintained itself throughout the 15th and the 16th century. In the Statute of Artificers 1562 or the Statute of Laborers 1603, laborers and the employed continued to be able, in the conflict of laws, to fight against the conservatism that preoccupied and gave a benefit to those who protected public property or private property. In other words, individuals could stand against the assumption and could protect their rights in the English court of law, despite the presumption that the English courts were conservative by default. This is very, very important because as we get into the 16th century, mercantilism began more and more to try and make individuals into property. And in some cases, the law was an ally in taking rights away from people. I'll just say it again. Sometimes the law was an ally in taking rights away from people. But sometimes the law defended the rights of individuals either to assume a right, to assume a liberty, or to defend one that existed already. For example, in the famous Russian case, it was of a Russian migrant called In the Matter of Cartwright, 1569. The court said that England is too pure an air for a slave to breathe. That's the paraphrased phrase. Not part of the ratio, but part of the obiter dicta, and relied upon in subsequent cases. Saying, in other words, that in England, enslavement is not legal. Now, this may seem strange to you, because you may have been told that England at a certain point was the largest slave trading nation in the world, which indeed it was. But at home, there was this strange legal anomaly between the conservatism protecting private property and another set of dicta, conflicting dicta, that was about the protection of liberties, the defense of liberties. This conflict of laws continued into the 16th century. There is the famous case of Hector Novames, an African who attempted to assert his rights and refused to work for his employer. And it was said that, in fact, it was the African who had a right not to be treated as an enslaved person so long as he asserted his right to be a free person. In 1640, however, there was a judicial hardening of ideas. The legal system in the latter part of the 17th century and beginning into the 18th century began to favor more and more its own antecedent roots and support private property over the rights of the individual. So in the case of John Punch in British colonial America, British lawyers were willing to say that, okay, we accept that the status of enslavement may exist. They ruled that in the question of status, it is possible that somebody can be indentured for the term of their natural life. And of course, this was the step-by-step process that led to enslavement, because what we must remember is that it was legal enactment, step by step, that reduced the indentured servants, who happened to be people of African descent or Native American descent, into the later status of becoming enslaved. This didn't happen by chance. It was, in fact, lawyers who were fundamentally in the process of making slavery legal. So this dicta continued in the case of Caesar and Johnson in 1654, also decided in colonial America, where it said that people of African descent were capable of being enslaved as well as other people. In fact, they named some other people, including Native Americans and some other indentured servants who were also capable of being enslaved. In the case of Elizabeth Key Grinstead in 1655, also in British colonial America, it was decided that, yes, it is possible to enslave certain peoples for certain reasons. Now, in the 17th century, lawyers were fundamental in the development of race laws. These are laws specifically designed and focused on making slavery legal and ensuring that those who were enslaved were Africans only. That's why they're called race laws. And those laws were implemented by English lawyers in Britain and in colonial America and other places too. But in Britain itself, it was often difficult to enforce these laws because of the community and settler status in British society, which we'll come to later. But in colonial territories, these laws were enforced very, very strongly. One of those laws was the Virginia Law of 1662, which resembled another set of laws called the Code Noir, which literally means the black or the code laws, the laws related to black people. They were laws created by the French. And then there was another system of laws created by the Spanish and the Portuguese. British colonial territories began to introduce piecemeal laws that concentrated only on Africans and on making them enslaved and separating them from other indentured labor. and let me just highlight again, it was lawyers that were fundamentally behind these measures, with the support, of course, of the economic interests. So in the 17th century, this meant there were cases like Butts and Penny, 1677, where it said that the African was capable of being enslaved since they were servants of an infidel prince. That's the term. I'm not laughing because it's funny. I'm just laughing at the terminology. And since they were servants of infidel princes, there might be a position where they could be enslaved. But throughout the 17th and into the 18th century, there were conflicting cases. In the famous Somerset case, the person of African descent successfully applied for their own rights to be protected. And the same in the Jonathan Strong case. But going back to Gregson and Gilbert, which is the Zong case, the rights of individuals were seen as minor to the rights of public property. Now, the famous Zong case of 1783 was a horrific case where the law failed. In that case, many people of African descent were being transported as enslaved people, as property. The shipwrights decided to throw these human beings overboard and then to make a claim for insurance for the loss of their property. The case went to court, and the court ruled in favor of the shipwrights, saying effectively that they could claim for their loss of property. Let us note that the law in this case was not concerned with the fact that human beings had been killed. Their prime concern was that those who had had their property lost should be recompensed for that loss of property. So that's a clear indication of blindsiding, of the law failing to see that there are fundamental questions regarding human rights and civil liberties that are actually being infringed, and the law protecting the status quo. So, of course, law in many ways reflects public opinion. Law is guided by public opinion. But what if the public opinion is overridingly xenophobic? What if public opinion is extraordinarily racist? What if public opinion is extraordinarily anti-Semitic? What if public opinion is extraordinarily Islamophobic? Well, the tendency has been that the law has defended that racism. The law has defended that anti-Semitism, and the law in some cases has defended that Islamophobia. There are some examples that might help us to understand this. The dicta that was emerging in the 18th century and the beginning of the 19th century that supported the enslavement of African people had a strong amount of support within Britain and the Commonwealth. The quote that I've just listed to you there, I've ever been and shall die a firm friend to our present colonial system, is a statement in defense of enslavement made by no lesser person than Lord Nelson. Other defenders of enslavement included people like the Duke of Wellington and individuals like Charles Dickens. There was a strong sense of sentiment in support of this inferior treatment and in support of the law defending this inferior treatment. So this sort of leads us on to the Abolition Act of 1807, where the law took up a position. Now, I don't want us to suddenly clap ourselves on the back, as some people do, and say that, you know, this is an instance where the law is firmly ahead of public opinion, because it's not. By 1807, in many corners of the Western world, there was a growing sentiment against enslavement amongst the middle classes, and a growing political agitation that sought to enforce an idea that there was such a thing as fundamental human rights. So this movement was fundamentally behind the movements that gave birth in the 19th century and in the 20th century to international human rights. There is a strong connection between the two. Now, the Abolition Act came on the back of insurrection, rebellion, and revolt, and on the back of a movement within middle-class European circles that it was unconscionable to maintain the peculiar trade, as they called it. The law followed public opinion. It certainly wasn't ahead of it. And we must remember, whilst we are not slapping ourselves on the back or praising ourselves for being at the head of change, that the Abolition Act is an extraordinarily conservative piece of legislation. And I ask you as lawyers, when we finish today, to actually look at the provision of the Act and see that the Act is primarily not a human rights act, but one of stated conservative public policy. And we must also remember that the Act did not make it illegal for Englishmen, Scotsmen, Welshmen, and Irishmen to ply their trade of enslaving people outside of Britain. They continue to do that in Jamaica, Barbados, Antigua, St. Lucia, in Virginia, in British Guyana, even in Canada, and in the continent of Africa itself, and in parts of Asia, and in Oceania. That continued. And that's why it was necessary to pass further acts, like the 1833 Act, the 1824 Act, the 1833 Act, and the 1874 Act. And of course, the legacy of this inequity was passed on to other institutions throughout the world who looked to British lawyers to set the example. The ripple effect meant that we may now look at the racism of America and the racism of South Africa as some strange anomaly, but in fact, it followed the legacy that came from this country. So we might, for a moment, just have a look at a case called Scott and Sanford, which later became known as the Dred Scott case of 1831. Please let us note the date, firmly after the 1807 Act. This is an American case decided in the United States of America and ruled upon, adjudicated by judges that are supposed to be dispassionate, objective. These judges ruled, and I want to just read out what it says. The question is simply this: can a Negro, term obviously referring to people of African descent, whose ancestors were imported into this country and sold as slaves, become a member of the political community formed and brought into existence by the Constitution of the United States as such, and become entitled to all of the rights and privileges and immunities guaranteed by that instrument to the citizen? It goes on, that Africans are not included, were not intended to be included under the word citizens in the Constitution. The Dred Scott case actually rules that Africans are not human beings, that they are 3/5 of a human being for tax purposes. Furthermore, it says, and that these Africans could therefore claim none of the rights and privileges, and let me just repeat, these are lawyers making these statements, that instrument provides for and secures to the citizens of the United States. On the contrary, they were at that time of the America's founding considered as a subordinate and inferior class of beings who had been subjugated by the dominant race and whether emancipated or not, yet remained subject to their authority, and had no rights, and let me just emphasize, had no rights or privileges but such as those who held the power and the government might choose to grant them. So this case is part of a series of dicta passed in the 19th century in various parts of the world by lawyers to justify certain people being less than human and treated as less than human, and by law being recognized as less than human. It goes on that a perpetual and impassable barrier was intended to be erected between the white race and the one which they had reduced to slavery, and they were doomed as an unhappy race, and that they were never thought of as anything other than property. Now, the key point behind the Dred Scott case, and this is the coup de grace, as it were, is that the leading judges in this case ruled on this principle because they believed that they were following a precedent which had been set by Britain and set by British legislators, who they regarded as being superior in regards to jurisprudence. So this is important for us to understand, so that when we view legislation like the 1807 Act and the 1833 Act, we can view it in context. We can see that lawyers actually have quite a reprehensible history in relation to equity. Let's just illustrate this point further, I'm afraid. The 1833 Act that some people champion as this hugely legislative act, giving rights and freedoms, the law being a sword for human rights. Actually, the principal purpose of the Act was to ensure that those who held enslaved people would be economically compensated for being relieved of their enslaved people by the Act. So the Act granted millions of pounds of compensation to the Cumberbatches, to Benedict Cumberbatch's ancestors, to David Cameron's ancestors, and others. It granted millions of pounds of compensation to these people for the loss of their enslaved people through the Act's auspices. That was the principal mischief that the Act intended to remedy, not to provide basic fundamental human rights or justification for those fundamental human rights. So, all right, there are just a few things, because of time, that I just want us to just sort of think about or clarify. I have chosen to talk to you today about one system of inequity, which is around the duplicity of lawyers in making slavery legal, in supporting slavery once they had declared it legal, and then in dragging their feet, even when public opinion was against the legality of enslavement. But we need to take this further, I'm afraid, because even when enslavement came to an end, the next phase of colonialism was firmly supported by law. The annexation of the entire subcontinent of India by the British government was sanctioned by law. The entire annexation of West Africa was sanctioned by lawyers. The taking into public ownership of Egypt was sanctioned by lawyers. The machinations that took place at the Berlin Conference of 1884 or 1885 were entirely legal. The system of indentured labor that was put into effect in India or Guyana or Trinidad and Tobago in the 1880s and the 1890s was passed through British legislative enactments, even though these acts had been passed. So there's a lot to go through today, lots to think about. The key thing that I wanted us to think about is that there is a sort of movement, I would say, a sort of political movement, and in other ways, to make people feel guilty for trying to make change or for trying to create equity. They will say, you know, what is this movement about? Is it wokeism? Is it political correctness? I don't think it's any of those things, and I certainly don't use any of those terms. I think that these arguments and these discussions are empty, because I think that when we begin to analyze history, and I hope that I've given you a window into that history, we can see the huge amount of inequality and inequity in the professions that we are part of. And that our professions have helped to create a huge amount of inequality and inequity, not only in this country, but throughout the world. Therefore, I believe we have a duty, nay, we have an obligation to redress the huge amount of inequality and unfairness that our professions have given birth to. And I'm afraid that I think we'll be spending a considerable amount of time trying to redress those inequalities and injustices because they are manifested and they are huge.
As we draw this event to a close, let me thank you, Dr. Nubia, for once again being our special guest and presenting such a fascinating account of the law, our history, and how it has influenced the landscape of race inequality. Thanks to my colleague Simone Thomas for all our efforts to shape today's event. And thank you to our Cultural Diversity Committee at Taylor Wessing and all our Cultural Diversity Network members, all our colleagues who have supported the production of today's event and I know are proud to be allies. And thank you, our attendees, for tuning in today. Please keep talking and discussing, generating ideas and debates so we shine a light on equality as a driver of a better way of life, a better way of working, and a better way of spending time with colleagues, and quite frankly, right at the heart of the values that equate to success in today and tomorrow's world. Addressing racial equality is a key part of Taylor Wessing's values, and we would love to hear from you. So if you wish to work with us, if you want to collaborate on this really important area, I'm sure that together we can really work together to move the needle on this. So if that's you, if you really wish to collaborate and do something great together, then please do contact me or my co-chair Tandip Minhas or your usual Taylor Wessing point of contact. We really do want to hear from you. Thank you again for joining us today, and stay tuned for more to come from Taylor Wessing's Cultural Diversity Network. Thank you and goodbye.